Hello, I'm Andy Agafangelo. I'm very proud to be the founder of campaign group Transparency Task Force. We are a certified social enterprise with a formal mission to promote reform of the financial sector so that it serves society better. That's why we exist. We're all about speaking up for the consumer. We're all about identifying flaws in the system that are preventing consumers getting good outcomes. And very frequently, that means that we need to pay a lot of attention to the work of the authorities, the judicial system, the regulatory system, those folks in Parliament hold the system to account, so on and so forth. As you all know, today's conversation is remarkably important because it is all about what may well turn out to be the single greatest financial detriment caused to the citizens of the United Kingdom. Mr. Paul Carlier will no doubt refer back to that point during the course of today's proceedings. The plan is this: at 4:35, or perhaps just before 4:35, we are going to show the live link to the Supreme Court, where we expect to see a judge read out the announcement about this phenomenally important case to do with secret commissions in the car finance sector. But please understand, this case is not just about secret commissions in the car finance sector. That may well be what the justice reads out about only. However, the case itself goes into many other areas as well, including whether the regulators did their job properly, and if not, why not? And also including, based upon recent press coverage, whether the Chancellor of the Exchequer might be under pressure to protect the interests of the banks at the direct expense of the consumers. I mentioned a moment ago that I'm a little bit behind schedule in preparation because I had an idea. And the idea was, maybe this is such a phenomenal event that we ought to actually get creative about it. And I thought, yeah, why don't we? So, ladies and gentlemen, you're about to hear over the next 5 minutes or so, we're going to be listening to a little bit of creativity that we knocked up. I hope you enjoy it. So pin your ears back, ladies and gentlemen, and hopefully enjoy what you're about to hear and indeed see. A poem. Oh, yes. No other organisation does this stuff, folks. A poem about secret commissions, willfully blind regulators, and a seemingly conflicted chancellor. Here we go. In gleaming halls of chrome and steel, where promises seemed strong and real, I walked with hope, my future bright. A salesman's smile will make this right. Trust me, friend, I know the way, the perfect deal for you today. Behind his eyes a secret gleamed, while I believed in what he seen. In boardrooms dark the handshakes made a shadowy and twisted trade. While I thought guidance pure and true, he worked for them, not me or you. Commissions slipped through fingers slide, built on trust and built on lies. The broker's mask so smooth, so clean, hid avarice behind the scene. Years rolled by like morning mist before I knew what I had missed. The honest man who claimed my cause was bending truth and breaking laws. The Court of Appeal raised its voice. This practice robs the people's choice. And suddenly the light shone through on what these hidden dealings do. £30 billion at stake. How many dreams did avarice break? Close brothers, Motonovo fight against the coming morning light. The highest court now weighs the scale. Will justice triumph? Will it fail? On this day of August 1st, will consumers' chains be burst? In halls where justice makes its stand, the future rests in wisdom's hand. No more shadows, no more lies, truth reflected in our eyes. Its fairness wins this bitter fight, and wrong gives way to legal right. Then trust betrayed might heal at last, and honesty replace the past. Let this be lesson, let this be song, that hidden deals are always wrong. When money flows in secret streams, it drowns the people's honest dreams. In courtrooms high and showrooms low, let transparency's bright light show that every handshake, every deal must be honest, must be real. For in the end, when day is done and all the secret games are won, the only victory worth the cost is trust regained and honour crossed. That's part one, folks. Paul's put his hand up. We're going to go to Paul, and then we're going to see rounds of applause. Well done. Made with my mate called Claude. You'll know what I mean, folks, when I say my mate Claude. Paul Carley, please do come in there. Thank you, Paul.
I've got another poem that I've come up with today, and it kind of applies to the whole spectrum of financial products. And it goes like this. Roses are red, violets are blue. If you're non-sophisticated, we'll screw you. That's my
That's your input. Fantastic, Paul. Okay, we'll come back to these creativities in a little while. What I want to do now, before I do anything else, is attempt to see whether anything is happening in the court case.
I've got the link open. I'm playing it, and there's just the Supreme Court logo, so it's there.
Okay. Ready to go. Lovely. Thank you very much indeed. In which case, I'm going to attempt to find something else. Bear with me, folks.
I do suspect that I think the lawyers will have known for some time on each side. I think I imagine journalists would have had some sort of advance notice under embargo. So I'm going to get Twitter open as well to see if there's any quick headlines come out from journalists as well. So
thank you very much indeed, Paul. Thank you. Okay. So, folks, let me just show you what we're looking at. Again, I'm going to share my screen. If we go to the TTF webpage, which has got the details about the event, you'll see here where it says the judgment hand down will be live streamed, and the link will be visible here just before 4:35. I'm going to put a link to this webpage in the chat now, just so you can get to it yourselves. If you wanted to do so. But if we can, what we're going to try to do is simply play it live. If we can do that, that would be good. This is what the page looks like. You still see my screen here, folks. I think you are. And I hadn't realized, actually, if you scroll all the way down, you get to not only a whole load of information about the case itself, you also get to the previous hearings, which I was unable to watch at the time. So these are the hearings back in April. It'll be quite interesting to contrast the judicial logic, if I can use that phrase, that resulted in the decision, and contrast that with whatever comes out today. So what we're expecting is basically this to come to life at 4:35, as Paul Kiley just said. Currently, we've got just a logo. So just to carry on talking for probably just another 4 or 5 minutes or so, what we're hoping to do tonight is all watch the Supreme Court's decision being announced, have a conversation about the decision and its significance. We're also hoping to put out a TTF press statement as quickly as we can put it together. Paul and I have been working on a basic draft of it, and we'll obviously adjust the draft in light of the detail of the announcement. In fact, we've produced 2 drafts. One is the version assuming the decision is basically pro-consumer, and one is the version if the decision is basically pro-bank. And obviously, I'll try to make sure we send the right one to the journalists, otherwise it could get very, very confusing. And whatever credibility I once had may go down the tubes. Does anybody want to? Is anybody itching to squeeze in anything in terms of a quick comment or question before we get to 4:35, which is in roughly 5 minutes' time? Can I go back to you, Paul? Anything else you want to kind of quickly cover off about the significance of today's decision, regardless of which way it goes? Just give us a feel for the significance and, frankly, the scale of the importance of the decision, Paul. Thank you.
I think it's going to be huge. Not necessarily, but the thing is, for me, this is a win-win for consumers. So, and what I mean by that is, if the Supreme Court does uphold this, obviously that's great. There's going to be additional redress for consumers over and above that which has already been determined by the Ombudsman decisions and the High Court in respect to the incentivised commission arrangements. That's a different thing. So this will give extra redress. So that's great, and it should take the bill up to 30+ billion. But what it will also do is open up the door for multiple other products where similar non-disclosure of commissions has been driving the market, and various arrangements and everything else. And all of these products, these practices are not just basically screwing over individuals. They're also rigging the market in terms of the market price. And where I think the biggest thing is insurance. I mean, I think if the Supreme Court upholds this, the insurance market there's more layers of commission in the insurance market than anything else. I mean, on one, like for a building insurance case I'm working on at the minute, there's an underwriter at the top, then there's 3 layers of parties beneath it. An intermediary, who then has an appointed rep, who then has a broker. All 3 layers get commissions. None of it's disclosed. And the effect of that is it keeps those commissions have to come from somewhere. So they're keeping the market artificially inflated. So car insurance, everything, that market has been rigged. So there's no competition because everyone's at it, the same as they were in car finance. All these lenders were prepared to lend as low as 3.9% in car finance. No one got 3.9%. Everyone got 10% above. I mean, we worked it out on our analysis. Easily 10% was the average. So I think but the one thing, when I say a win-win, if the Supreme Court overturns a Court of Appeal decision, then it's far from over, because there are 3 other unlawful, if not criminal practices that these lenders are up to that have been concealed by the lenders and the FCA to this day. So there will be a new class action coming that will focus on those other 3 practices that will basically not only prove that there was an unfair relationship, but also rather prove that did these lenders therefore perjure themselves in front of the Supreme Court to try and defeat this, because they were aware of these other practices that definitely made the relationships unfair. So, as I say, I think win-win for consumers, whatever happens today.
Thank you very much indeed. Okay, I'm going to refer now to the page we're looking at. Let's try and get that up again and see what's happening there. I want to make sure we don't miss the beginning of it, because that's important. And I'm very pleased to say that we've got Dr. Sam Rushworth with us as well today. For those of you that don't know, Dr. Sam Rushworth MP is co-chair of the All-Party Parliamentary Group on Investment Fraud and Fairer Financial Services. Sam, I'm really pleased that you've taken time to be with us today, especially given it's a Friday and it's 4:30. That's great effort, Sam. Thank you very much. And we'll hopefully have an opportunity to get Sam's reflections on the court's decision later on as well. I'm going to again share my screen because I want to make sure we do not miss the beginning of the session. I want to refresh this page. The website does say that they may be, there may be glitches, there may be hold-ups, there could be problems, so on and so forth. But let's make sure we don't miss the beginning of the session. Folks, we are recording this. We will be putting the recording out on social media. Please be mindful of that. If when you come to ask questions, comments, and we'll also be sharing the chat as well from the event too. It's 4:34. I'm quite happy just to kind of carry on chatting away whilst waiting to come live. I've got a feeling this must be one of the most tentatively awaited decisions for a long time. I mean, Paul, you follow cases like this pretty forensically. I mean, how significant is this as far as court cases go? I mean, we had the massive one, Tom Hayes and Carlo Colombo, just the other week, but this has got to be on the same kind of scale as that, would you say?
It has, because I think, and obviously the whole issue here is, the other issue here is, should we even be here? Because the FCA had all the information they needed in 2016 from me, and certainly in 2019 following their, their 2-year investigation, and they buried it. And then I and others like me then had to go to lawyers to try and bring claims, and we got the class action filed in July 23, and only then did the FCA kick in, because basically it was going to expose the fact that they'd buried it in 2019. So this is the bigger story here, is that none of this should be bloody necessary. This should have all been dealt with in 2016. And you've seen all the internal stuff I've got from this. They knew everything. They had everything in their possession to have taken action and didn't. So we need to get to the bottom of that. And again, it shouldn't be that individuals have to rely on the Supreme Court. It's in session now, Andy.
Yeah.
Okay, thank you.
Explaining why the court is handing down this judgment on a Friday afternoon. I should begin by explaining why the court is handing down this judgment by the Friday afternoon.
By
the Financial Conduct Authority, the FCA, that the outcome of this appeal, whatever it may be, may affect the price of securities issued by companies involved in the car finance market, and the market will need time to digest the judgment and consider its impact. Were to issue the judgment during trading hours, there would be a risk of market disorder. The court has therefore obtained the views of all parties, including, of course, the individuals whose claims are before the court, on a suggestion that the judgment might be given after the market had closed for the weekend. No party has objected. So that is what the court is doing in order to avoid causing unnecessary disruption. The court has before it 3 cases brought by individuals who bought used cars on hire purchase. In its simplest form, this type of finance involves a finance company buying the car from the dealer and the customer paying the finance company the price of the car over a number of years in the form of monthly payments of capital and interest on a loan. The finance company hires the car to the customer during the period when the monthly payments are being made and transfers the ownership of the car to the customer at the end of that period. So these agreements normally involve 2 back-to-back agreements. The first is an agreement between the dealer and the finance company for the sale of the car. The main matter it deals with is the price which the finance company will pay the dealer. The other agreement is between the customer and the finance company, under which the car is hired to the customer and the customer undertakes to repay a credit. The amount of a credit will depend on the price that the finance company is paying the dealer for the car and the amount which the customer pays as a deposit. It will also depend on whether the customer is to become the owner of the car once he or she has repaid the credit, or is being given the option to buy it for an additional payment known as a balloon payment under a type of arrangement called a personal contract purchase, or PCP. Other matters dealt with in the agreement will include the interest rate and the period over which the credit is repayable. In order to understand the court's decision in these appeals, it's necessary to understand that these two agreements, the one between the customer and the finance company, and the one between the finance company and the dealer, are dependent on each other, so as to form a three-cornered arrangement. The dealer cannot sell the car unless the finance company buys it. The finance company will not buy it unless it has agreed a finance package with the customer, and the customer will not agree the finance package unless it's on terms which are satisfactory to him or her. Since the car dealer has a commercial interest in selling the car, it follows that the dealer also has a commercial interest in the successful conclusion of a finance package between the customer and the finance company. For the dealer, this is essentially a sale transaction from start to finish. The car dealer's commercial interest in the successful conclusion of the agreement between the customer and the finance company can affect its behavior in a number of ways. Depending on the terms which the finance company is willing to offer the customer and the customer's response, the dealer may have to adjust its own position or persuade the customer to adjust his or hers. For example, if, as in one of the cases before the court, the finance company is unwilling to advance a credit under the hire purchase agreement, which is large enough to match the price the car dealer is asking for the car, the dealer may be able to arrange for the customer to take out a personal loan from the finance company in addition to the credit advanced under the hire purchase agreement, so as to bridge the gap. To give another example, if the monthly payments demanded by the finance company are more than the customer is willing or able to pay, then the dealer will have to find a way of reducing the payments in order to achieve a sale. One solution may be to reduce the amount of the credit, for example, by agreeing that the customer will not become the owner of the car when the credit has been repaid, but will have to make a balloon payment at that point if she or she wants to buy it. In other words, getting the customer to take out a PCP package rather than hire purchase of the classic form. Another solution may be for the dealer to reduce the price of the car. Another may be for the dealer to offer the customer additional benefits, such as a warranty, so as to secure the customer's agreement. Or, as in one of the cases before the court, the dealer may have a discretion to reduce the interest paid by the customer, although doing so may affect the commission the dealer receives from the finance company, a practice which has since been prohibited by the FCA. Another solution may be for the dealer to interest the customer in a cheaper car. An alternative for the customer may be to buy a car from a different dealer offering a more competitive or affordable package. The important point to understand is that the car dealer has a commercial interest in the negotiations over the customer's finance package, which continues until the transaction has been entered into. The customer's contract is with the finance company, not the dealer. But the customer does not deal with the finance company directly. Instead, the car dealer acts as an intermediary, obtaining the customer's personal, employment, and financial details and providing them to the finance company, obtaining an offer of credit from the finance company, seeing whether the terms are acceptable to the customer, and trying to resolve any difficulties that may arise. If an agreement is reached, the dealer then ensures that the documentation for the agreement between the customer and the finance company is properly completed. In undertaking all these tasks, the dealer does not act as the agent of the customer. It does not receive any remuneration from the customer. It does not give the customer any undertaking or assurance that it is putting its own commercial interests aside. It couldn't, because, as I've explained, it is pursuing its own commercial interests throughout the process. The dealer is usually paid a commission by the finance company. This may be disclosed in the documentation provided to the customer, or the documentation may simply disclose the commission of an unspecified amount may be paid, or it may say nothing about it. In these proceedings, 3 customers who acquired cars on hire purchase are seeking to recover from the finance companies the amount of the commission which the finance companies paid to the car dealers. Their claims are advanced on 3 grounds. First, it is argued that the finance companies bribed the dealers by paying them a commission, with the consequence under the law of bribery that the finance companies are liable to pay the customers an equivalent amount. Secondly, it's argued that the dealers owed the customers a fiduciary duty, that's to say that they owed a single-minded duty of loyalty to the customers and therefore were not permitted to have any personal interest in the conclusion of the hire purchase transaction. If that is right, it would follow that the dealer's acceptance of the commission was a breach of their fiduciary duty, and that the finance companies who paid the commission are liable to compensate the customers for dishonestly assisting the dealers to commit that breach of duty. Thirdly, it is argued in one of the cases, that brought by Mr. Johnson, that his relationship with the finance company was unfair, as that term is used in the Consumer Credit Act of 1974, and that the court should order the finance company to pay him damages. In the county court, the customer's claims were dismissed, either by the trial judge or on appeal, insofar as they were based on bribery or on a breach of a fiduciary duty. No final decision was reached on Mr. Johnson's claim of an unfair relationship. The cases then proceeded to the Court of Appeal, which held that all the customer's claims succeeded. In the cases where there was no disclosure that commission might be paid, the Court of Appeal held that the payment of the commission was a bribe. In the case where it had been disclosed that commission might be paid, but not the amount, the Court of Appeal held that the dealer had been under fiduciary duty and that its acceptance of the commission was a breach of its fiduciary duty, as the customer had not given his or her fully informed consent. In Mr. Johnson's case, where it's argued that the relationship was unfair, that argument was also sustained. So all the customers were held to be entitled to recover amounts from the finance companies equivalent to the commission which the finance companies had paid to the dealers. The decision of the Court of Appeal came as a shock to the car finance industry, as it conflicted with the assumptions which had been made not only by the industry, but also by the FCA as its regulator. The finance companies appealed to this court. The FCA was permitted to intervene, as were several other parties. The Treasury also sought to intervene, but their application was refused, as their arguments concerned the economic consequences of the Court of Appeal's decision. The Supreme Court is only concerned with the legal issues in the case. In the period since the Court of Appeal's decision, claims management firms have encouraged anyone who bought a car on hire purchase or with a PCP to sign up with them. And no doubt, a great many people have done so under the impression that they had a valid claim. But it was too early to form any view as to whether a valid claim lay on the basis of the Court of Appeal's decision, as the decision was under appeal, and it was only once this court decided the appeal that it would become clear whether the Court of Appeal had decided the cases correctly or not. For the reasons set out in detail in a judgment published today, the Supreme Court allows the appeals brought by the finance companies. However, we uphold Mr. Johnson's claim that the relationship between him and the finance company was unfair, and we allow the appeal in his case only because the Court of Appeal made a number of mistakes in reaching its decision. Retaking the decision on a proper basis, we award him the amount of a commission plus interest. The other customers' claims are rejected. We reject the claims based on bribery on the basis that the payment of a commission was not a bribe. Under the civil law of bribery, as opposed to the criminal law, a bribe is a payment made to a fiduciary, which creates a conflict with his duty of single-minded loyalty to the person on whose behalf he is acting. The law of bribery only applies to persons who owe a single-minded duty of loyalty and are therefore bound to have no personal interest in the matter that they are dealing with. In the present case, the car dealers plainly and properly had a personal interest in the dealings between the customers and the finance companies, as I've explained. They were motivated throughout by their interest in selling cars at a profit. It follows that they did not owe any fiduciary duty to the customers. Each party to the three-cornered arrangement, the customer, the dealer, and the finance company, was engaged at arm's length from the other participants in the pursuit of its own objectives. Neither the parties themselves nor any onlooker could reasonably think that any participant was doing anything other than considering its own interests. For the same reason, there can be no remedy against the finance company based on the theory that the car dealer acted in breach of a fiduciary duty in accepting the commission. It was not a fiduciary, that's to say, a person entirely committed to acting in another person's interests without any interest of his own. On the contrary, the car dealer was at all times pursuing its own commercial interest in achieving a sale of a car on profitable terms. In reaching the opposite conclusion, the Court of Appeal failed to understand that the dealer has a commercial interest in the arrangement between the customer and the finance company. The court mistakenly treated the dealer as acting solely in the interests of the customer once the customer had chosen a car and agreed a price. The Court of Appeal also attached significant weight to findings that the customers trusted the dealers and were in a somewhat vulnerable position. That was the wrong approach. A fiduciary duty of loyalty is not generated by feelings of trust or by vulnerability. It is not a form of consumer protection. It's generated by an undertaking to act entirely in another person's interests without regard to one's own. That was obviously not the position of the dealers, interested as they were throughout in achieving sales. The question of an unfair relationship raises different questions. The statutory test of unfairness under the Consumer Credit Act allows courts to take account of a very broad range of factors and is highly fact-sensitive. The court considers that the following factors will normally be relevant: the size of the commission relative to the charge for credit, the nature of the commission, because, for example, a discretionary commission may create incentives to charge a higher interest rate, the characteristics of the consumer, the extent and manner of disclosure of the commission, and compliance with the regulatory rules. That is not an exhaustive list. The fact that there has been no disclosure of a commission or only partial disclosure will not necessarily make the relationship between the customer and the finance company unfair. It is simply a factor to be taken into account in the overall balancing exercise. There are three relevant factors on the facts of Mr. Johnson's case. First, the size of the commission paid by the finance company to the dealer. It amounted to 55% of the total charge for credit. The fact that the undisclosed commission was so high is a powerful indication that the relationship between Mr. Johnson and the finance company was unfair. Secondly, it is highly material that the documents provided to Mr. Johnson did not disclose the existence of a commercial tie between the finance company and the dealer, under which the finance company was given a right of first refusal of customers referred by the dealer. Instead, the documents created and were intended to create the completely false impression that the dealer was offering products from a selected panel of lenders and recommending the finance product that best met Mr. Johnson's individual requirements. Thirdly, on the other side of the scales is Mr. Johnson's failure to read any of the documents provided by the dealer. However, Mr. Johnson was commercially unsophisticated, and the court questions the extent to which a finance company could reasonably expect a customer to have read and understood the detail of such documents, particularly when no prominence was given to the relevant statements. For these reasons, the court holds that the relationship between Mr. Johnson and the finance company was unfair, and that the finance company should pay the amount of the commission to Mr. Johnson with interest at a commercial rate from the date of the agreement. For the reasons I've explained, the other customers' claims are rejected. The court will adjourn.
Okay, I think I followed that, but we'll get Paul Carlier's first reactions, and then we'll get reactions from others as well. First of all, thank you all for being here again. Mr. Paul Carlier, over to you. What could you kind of break this down into two parts for me, Paul? Could you please, first of all, explain what he said without commentary? Just explain the gist of what he said in plain English for us, and then feel free, Paul, to take us into your thoughts on what he said. Thank you, Paul.
Okay, so there's kind of three issues here. The first one, he was very clear to say that he said the incentivized commission arrangements that have been banned by the FCA. Now, he didn't disturb that. So he's established unequivocally that that's a totally separate thing and that wasn't being considered by the court. Now, I put in the chat there, that's huge because in recent months, the lenders have been trying to create the narrative and force that issue into the Supreme Court sphere as well, so that on the basis that if the Supreme Court found in their favour, they'd seek to argue that it applied to everything. That was a huge part of the judgment. He's established that was banned by the FCA, and he didn't go near it, and that's incredibly important. That means the 15 billion that is likely to cut to consumers from that FOSS decision and the FCA redress scheme, that's happening. That's going to happen. It is still, Barclays may still seek to appeal it because the Court of Appeal that they went to was stayed because they were waiting for this judgment. I struggle to see how they could possibly win the Court of Appeal decision on that issue, given that one of the findings today about the excessive nature of it and the unsophistication of the customer, etc. So I think that's a big deal. Now, for me, I'll go to the last bit first. That bit about the excessive commissions, and it was unfair, right? It was unfair, right? And it's also very important that he established that it actually didn't matter what documents the customer had before them. The customers are so unsophisticated, they would not have necessarily have understood them anyway. That's a massive deal because, and this is the problem, and for the first time, I've heard somebody in oversight establish that. basically there's a presumption by regulators, lenders, and everything else that everybody is much more financially sophisticated than they actually are. And I've had this in the last year. 336 leaseholders at a specific this development. Their building insurer went into administration, and they were oh, well, that's it. You can't make a claim. And yet, all of them, and varying levels of sophistication, none of them knew that. Well, an FCA authorised and regulated firm goes under, you go to the FSCS. Everyone thinks the FSCS is just for banks going under. It's not. And that's just one example. Here, that ruling could be huge because, you know, he's literally said it didn't matter that the customer admitted he didn't read them, right? Would he have understood them anyway? And now you think about how many things that has connotations for. Insurance documents, all of these small print. This guy's saying, what he said there is that doesn't matter. The commission that was charged was unfair. And obviously with all of these cases, the incentivized nature of the commissions meant that they were all overinflated, right? So and that's obviously been established by the FCA decisions, and that's essentially been corroborated here. So that, and obviously where that's going on in other industries as well, that's going to be potentially really helpful. Now let's go to the bit that they decided against, or they found in favour of the lenders. The fiduciary duty, and was there a bribe? Was there this? This was always for me a bit of a stretch because, you know, for someone that's got a fiduciary duty, like you would expect your bank to have it, your pension trustee, somebody of that nature, where they're not expected to act against your interests. So for me, this was, you know, a difficult one to prove, but because there was no fiduciary duty, they then said that therefore it couldn't have been a bribe. The incentive could not have been a bribe, therefore a breach of the Bribery Act, which would have applied to certain rescission or something else. So, but I think this part of the decision has been compromised by the concealment of other unlawful practices that the lenders are up to, if not criminal in some cases, that the lenders and the FCA are continuing to conceal and suppress. Now, had the court been aware of these, maybe there was a different possibility of a different outcome. Obviously, we won't know that, but I do think that the court has kind of taken. There's probably a different way to describe the relationship other than the fiduciary duty, because I think that goes too far. That's like all or nothing. Well, that you're 100% committed to the interests of the customer. You could never really expect that, but there was a duty of some kind, surely. These don't forget, these lenders they're bound to act with honesty and integrity. So although this is the dealer applying the APR and selling the agreement, the lender knows full well that the dealer isn't being necessarily honest with the customer. So surely it's almost like they're allowing the fact that the dealer can exist as a litigation buffer for the party that did have a fiduciary duty, i.e. the lender. You know, so, you know, they had an obligation to act with honesty and integrity. So I do think maybe the pleading was too narrow, and I do think the court obviously that means the court's got the opportunity to say no fiduciary duty, so therefore there can be none of the other wrongdoing. I don't think that's necessarily true, and unfortunately this is one of these arguable points, but I do think there's an opportunity to bring a new case featuring the other three practices and establishing a different duty that existed to the end user. Because basically what this does, and if it's pleaded in this way, it says that, well, because the dealer was there, nobody had a duty to the consumer. Well, somebody did. This was a sale of a financial product. So who had the duty? So, and I can't believe that it can be accepted that because the dealer exists and sits between the two, that therefore nobody had a duty. Whereas if that lender was selling it to you directly, they would have a duty to you. They would have a duty to act in your interest. They certainly couldn't be mis-selling it or doing, you know. So I think there's a grey area, but far from over. I think overall it's a good decision. I think that part that went against consumers, I think that's open to a completely new claim on slightly different issues, and certainly adding the three unlawful practices that were never put before the court. Maybe the Supreme Court would have had a different view had they been aware of these 3 other practices that the lenders failed to mention when claiming there was no fiduciary duty or anything else. So it's not, but I think overall, I'm all right. It's not bad judgment.
Thank you, Paul. Could you tell us a little bit more about those 3 other areas? Because, as you say, the Supreme Court didn't look at those at all for reasons that have been set out. But tell us a bit about those other 3 areas. Then we'll go to comments from others. I think I can see we've got Ian Duffield's hand up. We'll invite Dr. Sam Rushworth MP to chip in as well if you'd like to. But back to you, Paul. What are the other 3 areas?
First of all, there was one. I should have mentioned this as well. There was one. He made an assumption that the dealer was trying to sell the car at the highest possible price. That's actually wrong, right? Because basically, and this is the other factor, and again, it comes from the law firms in the first place not having the full suite of facts. We've got various things in train at the minute. I've got car dealers, I've got whistleblowers, and basically, it wasn't their objective. In fact, the dealer wanted to sell the car for less, right? So let's say, for example, the dealer has bought the car for 20 grand. He's going to sell it for maybe 22 or 23 grand. However, he would prefer to sell that car for 20 grand and make no profit and make more money on the commission. So the dealer was actually incentivized to lower the price of the car, but jack up the price of the commission. And the reason for that is because there was no VAT payable on the commission. Whereas if he made 2 grand on the price of the car, he'd have to pay VAT, 20% VAT on that 2 grand. Whereas if he made nothing on the car but made 2 grand of commission, he keeps the whole 2 grand, right? So that's a really important mechanism within the whole process that the Supreme Court actually got wrong, because that is a key part that was never mentioned. And again, it was never mentioned because the lawyers or the claimants weren't aware of that. I know that because I've got 3 car dealer witnesses and whistleblowers who have explained that to me. So the premise that the car dealer wanted to sell the car for as much as possible was not technically correct. And in fact, he would sacrifice profit on the car for greater commissions on the finance. And obviously in so doing, you then expose the customer to greater damages or risks to the lender, because obviously your debt to the lender is bigger than it might otherwise have been, right? So because you'd have maybe got a slightly better, you got a better interest rate but paid more for the car. So there's an imbalance there. So sorry, Andy, your other question, I forgot what it was now.
Yeah, I was asking what were the 3 other areas? You talked about the VAT piece. Thank you.
So basically, all that really is the non-disclosure, disclosure of commissions. That was that was one of the issues here. The incentivized commission arrangements were mentioned because they've obviously, and they have been significant today because obviously the Supreme Court factored that into it being unfair, right? So the 50-odd% of the interest being paid as commission was wholly unfair, and obviously the reason it was so high is because of the incentives. So that's a really important issue. However, what the court didn't know, what the Court of Appeal didn't know, was there were 3 other unlawful practices. One was a stocking facility. So, and Black Horse had these everywhere, and so did all the other lenders. The stocking facility is in addition to the incentivized commission arrangement. The stocking facility basically is an interest-free loan to that dealer where they say, don't go and use your own cash to buy your stock, have an interest-free loan on us. However, in order for you to benefit from that interest-free loan, you have to put X amount through us every month, at the expense of any other lender. So now surely that the existence of that facility, surely that factors into the argument. So, and then there's another factor. Now, these 2 I think are incredibly important because these 2 other ones were brought in for the specific intent of circumventing the Consumer Credit Act. In 2013, it was announced that the FCA was taking over regulation of the Consumer Credit Act, and then from 2014, if a customer asked the dealer to disclose their commissions, then the dealer would have to disclose the commission they were being paid on that finance agreement. Now, that was a problem because obviously there's a gravy train here that they don't really want people to become aware of. So what they did, they introduced 2 practices. I'll do with the first one first, that had the sole purpose of which was to circumvent the Consumer Credit Act and the rights of individuals afforded by it. one of them was called a volume override. So now, let's say, for example, the dealer's due to get £2,000 commission on the sale of a car via this finance agreement, right? The dealer would now only get, say, £400. And the rest of it, the 1,600 quid, will be paid as an ex gratia top-up bonus at a date in the future. So therefore, if the customer asks, well, how much commission are you getting paid for this? Oh, just for 400 quid. Not a lot, not a lot. It's nothing to see here, because they were doing it. And don't forget, in 2014, obviously, Plevin came in as well and established that you cannot price a financial product from whatever you can get away with basis, the PPI judgment. So they knew that there was scrutiny on these, on the commission levels and everything else. So they literally, they brought in this practice that would see, the bulk of the commission deferred to a later date, so that they didn't have to disclose the true commission to the customer. Now, you tell me how that is lawful and consistent with the rights of the consumer under the Consumer Credit Act. It was brought in entirely to circumvent it. However, the worst practice, and I don't know, and I just cannot see how this is a criminal practice. And I've got all the documents. I've got the car dealer and a whistleblower from the lender who has confirmed all of this. The other problem they had, again, is all about the size of the commissions and everything else. So in December 13, this particular lender basically negotiates with the dealer and says, right, we're now going to pay you your commissions in advance. So they gave them 100 grand in the December, right, which was the advance commissions for this dealer. And then obviously that way, technically, there's no commissions payable on the sale of each of these future agreements. So if the customer asks, they say, oh no, nothing was payable upon the completion of this, no commission was payable to us on the completion of the sale of that unit, because it had been paid in advance. However, this is where I think it makes it criminal. These advance commissions were dressed up and disguised as loans to the business for business purposes and or marketing purposes. Now, how is that? And that's also designed to mislead the regulator. So the regulator looks at this, oh, it doesn't look like advance commissions, right? So I do have some sympathy with the FCA on that practice, but I'm sure they would have seen through the smoke screen if they did during their 2-year investigation. But how can advance commissions that are paid with a specific intent to circumvent the Consumer Credit Act, and this is all, and don't forget, these terms and conditions and these practices are all devised and forced on the dealers by the lenders. The dealers aren't coming up with this. Don't get me wrong, a lot of dealers more than happy to go along with it because obviously it was bigger revenues for them. But this all comes at the behest of the lenders. The FCA authorised and regulated lenders, right? They dress these advance commissions up, knew it's going to look bad, 100 grand advance commissions, it's still a problem if the regulator sees it. I'll tell you what, we'll just disguise it as a loan to you for business purposes. And then it would roll over every year going forward. And in that loan as well was another condition whereby to keep this going and to keep this loan interest free, for you, you have to put X amount of business through us at the expense of everybody else. Now, someone has to tell me why that's not criminal. And none of this was before the Court of Appeal or the Supreme Court. And that's because the lenders concealed it and so have the FCA. So
that's fascinating insights, Paul. Thank you very, very much indeed. We'll go to, let me just check in with Sam. Sam, I'm not sure what time we need to break away from the meeting. If you want to come in now, please do, or we'll come in later.
I've got till about 5:30, so I could come in after Ian if you want.
Ian sometimes gives us long explanations. Why don't you go now? Because I don't want to rush in. So feel free to come in now, Sam. Thank you very much.
I will keep it short, by the way, Andy. Don't worry.
I will likewise as well, because it'd be good to hear from other people before I have to run off and help a constituent with something.
And hello, Sam.
And hello again. Good to see some familiar faces on the call. As I always start out by saying, I'm not at all an expert in finance and in this area. My interest is that I'm a constituency MP with people who are so frequently disappointed and let down by our laws, and people who are victims of crime in many cases. And it sort of look at how can we improve people's living standards. It seems to me that, of course, increasing income is one thing, but actually protecting people from not being scammed is a really significant way of looking after people's well-being and interests, because it is frankly just far too common. And what I was interested in the judgment there, and I was I was thinking, I didn't know which way it was going to go, and I would always say this, that I will always support the decision of a court, because I respect the rule of law. That doesn't mean that I always like the outcome. And sometimes when we don't like the outcome of a court, it's because the court's job isn't to actually arbitrate on what's fair or not fair. The court's job is to tell us what the law says. And there are many instances when it comes to consumer protection where I think actually the law isn't good enough, and where we need to actually look at the law and do more. But I was really pleased that the idea was upheld around it being an unfair relationship. And I think the fairness of a relationship between the consumer and the company is really important, not just in this case, but in a great deal of the cases that we look at. And it, to me, this is a sort of fairly obvious philosophical point. If I break into your house and steal from you, I'm a robber, and because I've broken your window and I've taken what's yours. If I mug you in the street, I'm using, again, an unfair balance of power between me and you, the fact that I have a weapon and you don't. But if I can con you, if I can use my superior knowledge of a particular area of law or finance, and I can trick you into handing your money over to me rather than to somebody else, too often I think people's attitude to that is, well, it's buyer beware, it's the fault of the customer. But where that ends up too often is with people who lose their savings, or who find themselves with a millstone around their neck of debt. And so I was really pleased to hear that recognised. A question that I have for some of the kind of more expert people is, obviously in the case here, the Supreme Court cited that 55% of the overall cost of credit going as commission is too high. I do wonder if the court has a sense of where the line is drawn, and these do seem to me to be still subjective judgments, and so I wonder actually still if the law needs to do more to clarify, and particularly listening to Paul a moment ago, I think he made some really interesting points, and I'm always in these spaces to learn really rather than to talk. And I learned already from some of the things that Paul said that it seems to me that there are too many ways that again people can use sort of trickery to bypass the law, and so obviously that's something that we need to look at. Overall, I think I'm quite pleased with the outcome. Another thing I don't really understand yet, and until more experts explain it to me, is obviously in this particular case only one person's argument was upheld, but presumably the argument around unfairness could have applied to the previous two claimants had they chosen to make that argument, or maybe it depends on their individual circumstances. And so I'm not sure kind of what's next for all these people who've become excited in recent get a windfall of money. What is next for them? Because clearly not every case is going to be identical, and so I'd be interested to learn more about that. I'll stop there.
Sam, thank you very, very much indeed. I've just glanced through the BBC coverage, and what they've reported is different to what I understood from what was being said, and also I think from what Paul was saying as well. So maybe it's not all that clear. Maybe it's not that black and white. Paul, do you want to come in on that? Have you glanced at the BBC coverage, Paul?
Yeah, and I'm looking at the FTSE, and the FTSE's jumped. You know, it's recovered all its losses. Well, it's out of hours. This is the futures, but you know, it's up 50 odd points from the close. And you know, I think people are misreading this. I think the fiduciary duty thing, I think, was always a stretch. The unfair relationship, that was kind of what this was about. This was an unfair relationship, and you know, and as Sam pointed out, and I do think you're absolutely spot on. You know, it was all about the various pleadings. There's different pleadings here, so, and obviously, I don't think any of them got the whole thing spot on. So the Supreme Court is obviously only going to opine, as the Court of Appeal did before, on the specific pleadings before them. So I don't think any of it was completely correctly pleaded and summarised all of the issues that were at play here. Obviously the three practices being concealed is obviously that could never have been put before the court. So I do think I think there's massive room here that, to the unfair relationship. I mean, if it's an unfair relationship, all of these other products and insurance and everything else are being priced by, commissions influencing the price. I mean, that's evident. So I really do think there's much more to come on this. I think that's not bad. I think, and there's room to challenge or bring new cases to plead things correctly that will take advantage of the grey area that still seems to exist. And I think Sam's absolutely right. There is a grey area here because of the limited issues that were before the court.
Thank you very much indeed, Paul. It may well be this is one of those situations where it's actually going to take time to really figure out what the implications of the ruling are. Paul, thank you very much indeed. Sam, if you do need to get going, then please feel free to do so. But can I please invite everybody just to show our appreciation to Sam, because the APPG is very, very busy. Sam's a very, very busy guy, but it's absolutely superb that on a purely voluntary basis, he co-chairs it. And we're always very pleased to have your input, Sam. Thank you very much indeed. Have a good weekend. Thank you. Let's go to Ian Duffield, then to Trevor Meelan, then to anybody else that wants to chip in. Thanks, Ian. Thank you.
Yeah, thank you. I'll be fairly brief on this because I agree with most what Paul has said and actually what Sam has said, because my experience comes from consumer and contract law, which is where what I worked in and got my understanding. So it sounds grandiose of me to say I agree with the Supreme Court, but yeah, on the fiduciary duty, it's difficult to see really that there was one there in the first place, because the customer is not paying the dealer to arrange the finance product and he's not getting any commission from the customer. So this goes back to the old principle, when pension reforms were coming in about who was paying who. Was a financial advisor receiving a commission from the products he sold, or was he working for being paid by the customer? So I think that's like Paul said, that was always going to be a stretch. It was interesting what Paul said, of course, about the other things that have been going on, but that's down to how the case has been pleaded. And of course, a judge or a court can only take the pleadings that are put before it, not other things that may or may not have happened. If it's not been argued, the court cannot rule on it. So that's maybe an issue of how the barristers or the legal advisors for the customers pled the case. And then, of course, the difficulty is if you don't know what it is that's gone on, how can you plead it? So Paul's knowledge of what's been happening is crucial. And, maybe it would have been helpful had some of the barristers actually spoken to Paul about what he knows and what he's happened, so the right questions could have been asked. But then, of course, when it comes to the regulators are supposed to know above that, because the other thing I thought that, as Sam has rightly said, and Paul, it's great to hear the court underpinning one of the fundamental core issues of consumer protection, which is it's long been the case in consumer law and in contract law that you cannot have unfair clauses in contracts. And unfair to a consumer is the fact that the imbalance of power sits with the person with the knowledge. So the old bit of small print in contracts has long been outlawed, if you like, by the courts, to say if it isn't in the way that a reasonable person can understand it, then it is not lawful and is automatically unfair. And the same principle exists with unfair clauses, even in proper contracts, not consumer contracts. So I have to say, I think that the court has got it pretty much right without knowing the detail of the pleadings. So from what I can see, it is pretty much right. But the one thing I would like to know, this is just my last point, is how much then is this unfair level of commission? Obviously, the court has decided that 55% is unfair. And this sort of goes back to the old laws of usury. And then at which point is it going to be deemed fair? Now, it seems to me that a standard interest rate on many of these, just going off Paul's information that I've heard him speak about, seems to be around the 14-15% mark. So somewhere there's going to be a line between, I would suggest, 15% and 55%. And you can look at credit cards which charge 30%. But in the case of a contract for a car and not a credit rating where the customer's future prospects or ability to pay is a significant issue, where's that line going to be? I would suggest that probably anything over 30%-ish is going to be dead in the water, because that's a typical 25-30%. It's a typical credit card level. So I think it's going to be somewhere around 30 to 50 of where the line is going to end up being drawn is to what it's going to be automatically unfair, unless there are very, very exceptional circumstances, if it is an unsophisticated borrower. So that's my thoughts on it. I think generally the court seems to have it probably about right. But the final bit is how many of these big interest issues are out there, because if something is made available to the public to say this is the sort of level where it becomes unfair, then we may see lots of consumers jumping up saying, wait a minute, I've been charged what has been 38%, 35%, whatever. And so I think that's going to be the interesting bit if this situation develops to that point where there's an indicator given of what is going to be automatically unfair.
Thank you so much, Ian. Thank you very much. We're going to go to Trevor, then to Johnny, then back to Paul. But before we go there, one of the things I always think to myself is, has what's happened, whatever the what is, has what's happened increased or decreased the public's trust in the financial industry? And I can't help feeling that the Supreme Court has just made the statement, in effect, that the finance seller has no real responsibility to the person they're organising the finance for. That's probably an oversimplification, but the judge did seem to stress the idea that the seller was acting purely and only in the seller's interest. What's that going to do to people's trust if they can't trust the people they're dealing with? I'll leave that question there. We'll go to Trevor, then to Johnny, then to Paul. Trevor, thank you.
Thanks, Andy. Sam, you might be interested. I was missold by Lloyds Bank. A good case is Wood versus Commercial First, which also ties in with Plevin versus Paragon. I may ask Nigel Harper to come in a minute. On the 11th of this month, my house, I can show you, was raided by Kent Police, High Court bailiffs, done by DLA Piper, Lloyds Bank, and they were all thugs. The police will not investigate fraud. My house currently, it works, looks like this. There are a load of immigrants in my house now, which probably come over on a dinghy, and I've seen that at others. When they came into my house, there was me there with my son, and every window has now been smashed in the house. Bailiffs are not allowed to force entry. This is what's happening, Sam, and our politicians don't want to know. My house has been smashed to pieces. We had Lloyds raised
Forgive me, Trevor, I've muted you. I'll tell you why I've muted you. With the greatest respect to you and your situation, okay? What you're raising is well out of scope for this particular conversation. So bear with me, Trevor. What I'm planning to do, what I'm very, very keen to do, is create an opportunity for what's happened to be explained in
Andy, my case is about
forensic detail, Trevor. Forgive me. I am going to keep you muted, Trevor, because we have a very, very focused conversation tonight, okay? Please allow me to mute you. Please stay muted. And we're going to go to Johnny Timpson in just a moment, because I'm very, very keen that we stay focused on tonight's conversation. I genuinely believe, as you know, Trevor, that what's experienced is absolutely awful and is worthy of an event in its own right, which is what I plan to try to do. Thank you very much indeed for your understanding, I hope. Johnny Timpson, we'll go to you, then we'll go back to Paul Kyler. Thank you very much. Thank you.
Yeah, thank you, Andy, and Ian, thank you for your comments. And one of the things that's concerned me as a member of the Financial Services Consumer Panel for quite some time, and I've been pushing the FCA really hard on this, well, there's kind of two things. If I look at the life insurance marketplace first, is the fact that, you know, for quite some time in the UK now, we've had loaded intermediaries and insurers had been putting commercial agreements in place to load up premium rates to drive out higher commissions. And these commissions are then basically paid to firms on an indemnified basis, so they get them as a lump sum. And they're kind of in the region of about 250% of the first year's premiums. If you kind of put that into an annualized amount, you know, and I express it another way, that's probably about 40 to 50% of every single premium the person pays over the lifetime of the product. And by and large, that's undisclosed. So you know, one of the things that I've been pushing the regulator as part of it, I wanted the pure protection market study that we've now got in progress, and I wanted them to specifically look at that issue. I certainly do think that we've got a problem with life insurance commissions, and hopefully today's judgment actually might just enable us to move the dial on that. The other thing that's concerning me is basically payment is premium credit and the rate of commission that's been paid there. Again, for quite some time, I've been pushing the regulator on that. I was quite disheartened the other day, actually, because the fact that, you know, whilst I didn't want them to ban premium credit, because otherwise you make insurance inaccessible for a large number of consumers. But I think that I certainly think that we needed a cap. I certainly do think at least we need a decency rate, because if you, as a regulator says, if you want consumer duty basically to sort this market out, then we need to basically know what good looks like and hold people account for going beyond that. So one of the things I've been discussing, in fact, I did it this morning with the Financial Inclusion Commission, and I'm meeting another couple of consumer groups next week, is that if the FCA are not going to put caps in place, I think we need some decency limit established that is pulled together by consumer groups and maybe academics in terms of you know, what do we think is fair, and anything above that rate needs basically an explanation to justify it. Otherwise, I don't see how we're gonna crack half of this, to be quite truthful. Sorry, Andy.
Don't apologise. It's great to get your view. Thank you very much indeed. For those that don't know Johnny, as Johnny mentioned at the very beginning, he's on the FCA's Financial Services Consumer Panel and does a great job there. Johnny, thank you very much indeed. I think we're going to jump back to Paul Carlier, then maybe to Ian Duffield and anyone else that wants to chip in. It's a very lively conversation. Thanks, Johnny. Paul, thank you.
Yeah, I mean, looking at some of this coverage, so the PR firms have been out in force and like spinning this as a big win for the lenders. I mean, I get the win on the bribery thing. I mean, you know, that was a bit of a stretch, and obviously the fiduciary duty issue. But on that issue, as I said, there's so many grey areas here, you know, that are still to be explored, because it's quite clear the Supreme Court made some errors of fact, not because they made an error, because obviously they're saying about this issue about, oh, the car dealer wanted to sell the car for as much as he possibly could. Not technically true. In fact, they would rather subsidise the price of the car and jack up the interest rate, which is obviously not in the interest of the consumer, because you're then more indebted to a firm that could then come and seize your assets if you can't keep up with the monthly payment. So there's a whole, you know, there's so many grey areas here, but I can't believe that that's being spun, given that it has established as an unfair relationship. And one of the big things was that it didn't matter that the guy didn't read the terms and conditions, because he wouldn't have understood them anyway. And that's exactly, that's the key. Now, that must apply to every financial product, right, that has been sold on this basis. Now, don't get me wrong, I mean, but my biggest thing is the mechanics of all of this, as I said before, right? Surely the Supreme Court does not accept that it should be permitted for the banks or the lenders to stick a dealer or agent or broker between them and the customer, and then by doing so that takes away any fiduciary duty the lender has, and takes away essentially all of the honesty and integrity obligations that the lender has, and disclosure obligations that the lender has to the customer. We're going back to self-cert mortgages in terms of in 2004, when I know for a fact that a subsidiary of Lloyds, Birmingham Midshires, they realised self-cert mortgages are a massive problem for them, because Jesus Christ, this is just take anyone's word for it, just so they could sell these big mortgages, get loads of commissions and everything else. So what did they do? Did they stop selling them? No. They then changed the rule so that a customer could only get a self-cert mortgage if they went via an IFA. So they put the IFAs in the middle as a litigation buffer, and then when all of these went south, the IFA told us it was all. That's what they did. Now, how? And I think the car dealers are kind of being used as the same issue. And I think I'm talking with lawyers at the minute, and we've been waiting for this decision so that we could work out what the court is thinking on these particular issues, identify the flaws, and then fill the gaps and bring proper pleadings that will take away these grey areas and really, and also hopefully beg the question that have some of these lenders overstepped the mark and been less than transparent and honest with the Supreme Court? Because they were all saying there's no unfair relationship in the first place. And but yeah, this whole issue, fiduciary duty or not, I think this is a big deal, because you can't say that people's rights and the obligations of an FCA authorised lender were no longer applied because of the existence of somebody in the middle that was an agent who apparently had no fiduciary duty whatsoever. I don't see how that can exist in this regulated landscape. I just don't. So, but again, that wasn't pleaded properly, so therefore there's this open-ended thing. So yeah, but the coverage, I mean, how is this being seen as a big win? I mean, it's not the best outcome for the consumers, but I think it's a huge outcome. I think it's 70% in favour of the consumers, I would say.
Interesting. Is it possible, Paul, that the coverage so far indicates or implies that there's going to be no compensation at all?
Well,
if you kind of read the headlines, yeah, it seems to be the message, doesn't it?
Well, I mean, I don't see. I mean, right. The most important thing for me, and as you know, incentivised commission arrangement has been my bugbear since 2015 when I found out about it and reported it. It took me 8-9 years to get that bloody thing properly exposed and get redress. Now, obviously, in recent months, that's been under threat because the banks have all been trying to say that, oh, the Supreme Court's deciding on everything. So if the Supreme Court finds in our favour on these issues, it means that the FCA decision is kicked out and we don't have to pay anything for the incentivised commission arrangements. And there's been 15 billion in redress, sort of hanging in the balance a little bit on that. Well, you heard him today. The first thing he said, incentivised commission arrangements banned by the FCA. He didn't say, in our opinion, that's wrong, that these arrangements were lawful. He didn't go there at all. So he's essentially endorsing the FCA's position on that. And then when they came to the unfair relationships, essentially the incentivised commission arrangement played a factor in that, because how did the commission get so high? The incentives, right? So again, that's been endorsed, right? So that's 15 billion that was kind of hanging in the balance. That's now going to be paid. There's no coming back from that. And I think you've probably, instead of getting another 15 to 20 billion as people were hoping, because the Court of Appeal decision would entitle people to the rest of the interest they paid back, right, there's still going to be a bit more than would be because of the commissions that have got to be returned, right? So this is I just don't see, and obviously how many other sectors, insurance especially, is this going on in, right? So you've now got the commission, that was an unfair relationship. This will apply to all of these other sectors as well. I think this is being rather spun. Is it 100% a win for the consumer? No, but it ain't a big win for the lenders as being portrayed here. I still think this is 70% in favour of the consumer, with the door still open to go and get this done properly.
Some fascinating stuff, Paul. Thank you very much. Back to Ian Duffield, then we'll go anywhere else that we take the conversation to, then we'll begin wrapping it up. Thank you.
Yeah, I'll speak first about what Paul's just said, and then I really want to address the points that Johnny Timpson raised, because I have some very strong views on that. The win here for the banks is the one of certainty. Lloyds, a week or so ago, announced their results, which were very favourable. And their share price has been very, very strong and still was today. But the win from their point of view is the fact that they put aside, I think it was 2.6 billion for their exposure in the car loans financial issue. So
1.2 they upped it to in February, I think.
Paul just said they've upped it to 1.2. Carry on, Ian. I think we've lost Ian's connection. Let's go to Lisa King while we're waiting for Ian. Lisa, thank you.
Hi, Andy. Hi, everyone. Hi, Paul. I am so confused. I don't know if I'm coming or going. I didn't know. I didn't know if he found in favour of the consumer, if he found in favour of the banks. It was just so wishy-washy that I haven't got a clue what went on there. I just listened to him talk a load of blah, and then he got up and walked out, and everyone's going, "Oh yeah, but that was really good for the car finance." Yeah. Is it? Is it good for the consumer? Because I have no idea.
I think I feel a bit like yourself, Lisa. I was reasonably clear in my. Joan Finch just put a note in the chat here. Joan says one BBC headline says millions deny car finance compensation payouts after Supreme Court ruling. Interesting, isn't it? I think we've got Ian Duffield back. Thanks, Lisa. Thank you very much. I feel good about being confused because you're not the only one. Ian Duffield, I think you're back, sir. Do you want to carry on with where you got to? Where's Ian? I think you lost Ian. He's got a bad connection. Would anybody else like to come in that hasn't yet had a chance to speak? Paul, why don't you pick up from there? If you don't mind, Paul, is it conceivable, I'm going to put this question to you again, is it conceivable that it is as it's being reported, i.e. there's not going to be any compensation? Has the judge basically said, the people you got your car finance through did not have any responsibility to you, therefore the fact that they didn't disclose the commission's kind of irrelevant? Is that what the guy just said?
No,
Paul?
He didn't. Basically, he specifically said that,
I heard that.
the FCA has banned those incentivised commission arrangements, right? Now, that's a big deal for me, and that's probably the most important takeaway, because I think everything else I always saw as, well, the Court of Appeal, did it go too far given what was before it? And I think this judgment's done exactly that. I think it was a stretch to say there was a fiduciary duty, not because there wasn't necessarily one, but because the full terms of the relationship were not before the court. So how could the court determine if there was a fiduciary relationship or fiduciary duty or any other duty, given that the court was never aware of all of these other practices that governed the relationship and the duty? So I think, yeah, I just don't. I'm just over the moon that 15 billion is going to be. That's not now no longer up in the air. The Supreme Court said it right now, and also let's not forget that it was the incentivised commission arrangements that would have meant that the commission that on the case that was upheld was so high. So that's another endorsement of the unfairness and unlawfulness of the incentivised commission arrangements. And he didn't disturb anything that the FCA is doing on that. And there's nothing in here today that makes me think that Barclays have got anything to go on when they try and appeal that decision at the Court of Appeal on the incentivised commission arrangements, because the Supreme Court has ruled that the level of the commission paid in that case was unfair, and that did establish an unfair relationship, and the level of commission is determined by the incentives. Boom. So I think Barclays is going to have to drop that Court of Appeal, or they're going to get another kick in that court as well. So for me, 15 billion incentivised commission arrangements, which has been my life for 8-9 years, that's happening. That's going to happen, and that's big. and our door's still open on the other stuff. And there's going to be additional commission over and above, additional redress over and above the 15 billion, because obviously they're now saying that the commissions have to be returned as well. That's in addition to, you know, what's already being paid. So that, now in some cases it might only be 5% of the amount of interest paid. This guy was 53%, right? So that's a big deal. It might only be 10%. Either way, it's another pot. It's another pot of cash that people are going to get. So I don't see, and the rest of it, the door's still open because of these other practices, and the full and a properly pleaded case will reopen that can of worms and expose the can of worms properly next time.
Thank you very much, Paul. We're going to go to
another thing to mention as well. The great thing is, it's not a challenge of the Supreme Court decision, which can't be challenged, right? That's done.
Yeah.
But it's because these are new. This is new evidence, new practices that were never before the court. So it doesn't. These claims, the door's wide open for these, and this, what this does today, it helps the lawyers come in next, and the lawyers I'm working with, get the pleadings right on everything, and take the bits that are there in our favour from the Supreme Court decision and go and really nail it and look at this relationship, establish properly what this relationship was and what the existence of the dealer in between the lender and the customer actually meant. Because nobody's put it to the Supreme Court, well, okay, so did the existence of the dealer between the lender and the customer mean that the dealer had no duty, the lender had no longer had any of the duties to the customer that it would have had if it was selling to them direct? That's a really important issue.
Really fascinating stuff. Well, thank you very much. Mr. Brian Hall.
Yeah, I'm just really interested in the outcome of all this. And I take my hat off to Paul Carlier. Well done, mate. A great analysis, both before and after the judgment. Very informative, very interesting. What I'm interested in now is what TTF should do moving forwards, because we've had this discussion, but what initiative should we take to perhaps clarify the situation as we see it to those victims, and in particular with regard to the regulator, because we have a side project, this Project Refute. What does the judgment mean in relation to the performance of the regulator? What conclusions can we draw? How can we move that initiative forward in this post-judgment world? So rather than just being passive, I think there's an opportunity for us to be proactive, take the initiative, and contribute to the debate. So that's my question really for you, Andy. What do we do next?
I think over the course of the next, I'm guessing, a week, we fully understand the decision that's been made and the implications of it. I've issued a press statement just now calling for a civilly actionable fiduciary duty. I think that's going to be necessary to rebuild trust in the market. The Supreme Court decision today, I think, is going to further undermine the trust and confidence people can have when they're buying financial services products, because the judge made it very clear. He didn't quite say it this way, of course, but he basically said, don't expect others to look after your interests. And if that's the market we've got, then it's not a million miles away from caveat emptor or buyer beware. And that's where we were prior to any regulation at all back in the 80s. So I think we need to take time to fully understand the implications of what's happened. Think about campaigning for a civilly actionable fiduciary duty or duty of care, and also encourage the idea that the regulators' lax handling of the information given to them by Paul Carlier, which they should have acted on very, very quickly, warrants further scrutiny of the regulator. Brian, thank you very much indeed. I think it's pretty clear where we're going with it. I'll pop the press statement that we issued in the chat in just a moment. Ian Duffield, good to see you're back, Ian. Back to you. Thank you.
God, I hate Zoom with a vengeance. You know this, Andy. Yeah, what I was saying before, Paul, my screen completely froze, but you were in the process of mentioning a figure, I think.
Yeah, they initially set aside 450 million last year, and in February they upped it to 1.2 billion, the provision. So I don't know if they've upped it since, but there's a really interesting thing now though, because I asked Budenberg at the AGM this year, like I addressed them last year on this. I said they were lowballing their provision of 450 million, and that it would be, they knew full well that it would be a minimum of 2.5 billion for compensation, admin and legal costs, if only the Ombudsman and FCA judgment specific to the Incentivised Commission arrangements held, and a minimum of 4.5 billion if the Court of Appeal decision held too. And therefore 450 million was a deliberate lowball intending to mislead the market, and they were going to, with the intent to drip feed further provisions in over time so that it didn't affect their share price. And obviously that February this year, they upped it to 1.2 billion. At the AGM this year, I challenged him on that and said, well, does that not prove that I was right? You were going to just drip feed in further amounts so that you could, the low ball last year would do exactly what you intended it to and get your stock price to recover after the initial drop when the FOSS decisions were first announced. He denied it, and he said, no, the extra money provision was made after the Court of Appeal decision. So I said, okay, therefore the Supreme Court overturns that decision, then presumably you are going to go take that away and take the provision back down to 450 million then. And he wouldn't answer. Because no, of course, it had nothing to do with it. It was part of the drip feed thing. So I'm going to challenge him on that again now. Well, now that you think the Supreme Court's gone your way, you're going to put the provision down to 450 million? They won't, because they know full well it's not 450 million, the true cost. It's going to be still in the region of 2.5 billion.
Yeah. The 2.6 billion was coming from my memory. I could be wrong on that, but I mentioned the figure about a week or two ago in a Zoom meeting because I've just read, because Lloyds had just reported on the closing of their latest quarter and announced the dividend. In my mind, it's 2.6 billion, but it was in the billions, certainly. But the point about it being good for the banks is because they've now got a certainty about what it's going to be, because the danger here would be if the Supreme Court had found for all three claimants, or for all three appellants, sorry, not the claimants become appellants, then the floodgates were going to open, at some very, very huge figures. So I think that's why there's a huge sigh of relief and joy in the banking fraternity. What it doesn't do, of course, is deal with the fundamental issue about what you said at the start, is why are we even here? The fact that this could have been stopped or should have been stopped years ago. So when it comes down to the regulatory side of things, that's where the real problem is sitting here, and that's where the regulator needs to step in on behalf of us unsophisticated consumers, i.e., the small people involved in this contractual side of it, because that is what the regulator's job is supposed to be. So that's the other side of this coin. In respect of what was being said about the large commissions and where does this sit, where does this play to? Before I retired, the area the company I was working for, the area was one of compliance, and I'm not a lawyer. My legal knowledge comes from commercial experience, which was why I was eventually in the role that I was in. And this goes back to what Johnny Simpson was saying. One of the things that I encountered, and when I was put in charge of compliance, pushed hard to put a stop to, was this idea of paying out huge commissions to salespeople on multi-year contracts, typically 3 or 5 years, whatever it may have been, but paying the full commission up front. Because what's supposed to happen within companies is if they have a long-running contract, they're supposed to defer profit on this, and they may well get paid all up front. This happens with, say, software licensing. You take out a Microsoft software license, and it might be good for 3 years, but what they should be doing, and I don't know whether Microsoft do or not, but they should be splitting the total value of that contract up into 3 elements and defer the profit, so they don't show all the profit up front, because because they have a liability for 3 years and therefore mustn't or shouldn't take the benefit, which is the profit on that sale, all as one lump sum. But typically, sales commissions are paid in this way, which to me was very wrong. What should happen is a salesperson sells something, it's the 3-year contract, they should receive their commission spread over 3 years. Of course, the problem is that means that they then become tied to the company they're in, which is why salespeople don't want it and sales directors don't like to do it, because usually sales directors are on commission also, as are the CEOs. So one of the problems that we see in the financial industry is massive commissions, because it's a very profitable area, because there's no cost of holding stock, there's no transport, there's no cost of manufacture. So it means that a price can be set with a very high level of profit. It's not like it is in the retail arena or in the manufacturing area, because the costs are so very low. It's only about the cost of money, and you don't have to ship it in trucks. So that's one of the problems here, that these big commissions are getting paid up front, and that is where the large percentages of these issues can come in when we're talking about interest rates. So there has to be something set somewhere, and it seems to me that needs to be the regulators getting involved of that, as saying anything above this rate will automatically be unfair unless there are very exceptional circumstances. Yes, it will always be upon the facts of the matter. If you've got a good credit rating, you can borrow at 3%. This goes back to the LIBOR issue. If you've got a bad credit rating, it might be 10%. But at what point does it become automatically unfair before you take into account the individual facts, which would be up to the lender to justify why they're charging a higher rate than what is seen as acceptable? And that, it seems to me, must form into the realm of the regulators.
Thanks very much, Ian. It really is quite interesting. We'll go to Nigel Keynes in just a moment. It really is quite interesting that there was talk about unfair. It's the phrase unfair is not really what you would associate with a court ruling, is it? Nigel Keynes, thank you very much indeed.
Sorry, Andy, just let me come back to that. Actually, the whole principle of the courts is to look at fairness when it comes into matters of this, and that's the whole underlying principle behind consumer law, consumer protection.
I understand, but if one of the appellants won on the basis that the deal was unfair, that brings up the point you've made, which is how do you define what is and what isn't fair? Thanks, Ian. Let's go to Nigel. Thank you.
Yeah, I did put a question earlier on into the chat. Perhaps it doesn't warrant, isn't worthy of being asked. It's only a speculative question.
Nigel, why don't
the judge said, sorry?
Why don't you ask the question?
Yes, that's what I'm trying to do, Andy. The question is that the judge said that the FCA made the assumption that the dealers were acting correctly. Now, it didn't make any comment as to whether the FCA was entitled to make the assumptions, or indeed what those assumptions were. But my point is that the FCA could have brought this matter to the court as a test case at a very early stage and had the matter decided, and then there would have been certainty in the market, and there wouldn't be the complaint that the thing has been up in the air for so long, because that's wholly the fault of the regulator by not bringing a test case, and that point doesn't seem to have been raised.
Nigel, thank you very much. You'll see the press statement we put out a little while ago focuses on the issue. Well, two things. One is the need for legislation to introduce a fiduciary duty so that consumers can have trust and confidence in the people they're dealing with. And the other is the very point that you made. There needs to be an understanding as to why the regulators have handled the matter the way that they have. Thank you, Nigel, very much indeed. Does anybody else want to come in with any other comments before we bring this very interesting conversation to a close? Oh, I don't know if you've seen the link to the judgment. I was wondering whether yourself or anybody else might be able to whack it through ChatGPT and get an exec summary of it or something like that.
Yeah, I'll do that. I'll probably have to do it over the weekend now, but you know, I think it's yeah, it'll be interesting to see what ChatGPT makes of it. But as I say, I think my take, I'm encouraged. I think the door's well and truly open, and I think yeah, I think it's a good outcome for consumers. It's not the worst outcome for the lenders that it could have been, but you know, the worst outcome is still to come because it leaves the door open for a properly pleaded case on all of the issues where we can go, right, these are all the blanks that were left by either inadequate pleading, not because the lawyers didn't do a good job for the claimants, because they didn't have all the facts, right? So now that we now know all the facts, we now know what the Supreme Court was thinking, bang, proper pleading that fills in all the gaps and really addresses these issues. Okay, well, what, and that for me is, well, what was the relationship? If it's not fiduciary duty, what was it? And why, you know, how does the existence of the dealer mean that the lender doesn't have to act with honesty and integrity, which is the core principle of, and it has to be fair, clear, and not misleading. Remember all this, you know, these FCA print, right? So the lender no longer has those responsibilities to the customer if there's a party in between. How does that work? That cannot be correct and isn't correct, because so it just needs to be tackled and pleaded in the right way. So I'll leave it there.
Thank you very much indeed. I've just put the verdict out on social media as well. Just final call for any other comments that want to.
Andy, could I say something here? Tony Lawler here.
Yes, please, Tony. Thank you very much.
Watching very intently from America, and it strikes me, just listening to it, as been a judgment that is more set out to contain rather than let the whole thing go where it should probably go. It seems to me as if it's kind of a damage limitation exercise, where they're trying to, what I would believe is that there's policy reasons behind this. Like, it is very clear from the outset that the timing of the judgment, when it was been announced today, was to coincide with the market closing, the way there won't be a reaction from the market. So it was obvious that there was a damage limitation concept employed by the court. So for that reason, I would think I'd agree there with Paul that there's a lot more avenues now to explore, that this should be taken kind of as the starting point. But I think from trying to get the nuances from the actual judgment itself, I think it is more damage limitation rather than anything else. They are fully aware of the impact that this would have, and the reaching effect it would stretch into other areas where commissions are involved, and it would blow a huge big hole in the whole lot of it. And when it comes to a monetary putting a value on this, like, let's put it to 15 billion that Paul talks about, it would be multiples of that money to redress it if they didn't try and control this and use it kind of as a controlling exercise more so than anything else. Because I can't see, I would also agree with Paul about this whole thing about being unfair and all this, like it's deep rooted in the whole system, the entire system, every aspect of it. And that's the way and that's just the way the judgment seemed to me, as if it was more a damage limitation exercise set out there to control a narrative. And you see yourself, the minute it was said that two appellants that it wasn't going to work out in their favour, that appeal was going to be allowed. You can see the big firms were on putting it out there straight away. That's a win for the banks and this, that and the other. So it's all about controlling the information and damage control, I think. That's what I had to say, Andy. That's all.
Tony, thank you very much indeed. Given your, I see your hand, Howard. I'll come to you in just a second. Tony, given your legal background and your ability to use AI, perhaps run the decision through AI and see what it comes up with. Thank you, Tony. We'll go to Howard, then we'll go to any other business, then we'll wrap up. Howard McNulty, any?
Thanks, Andy, and thanks for a very interesting session. I did actually put this through the ChatGPT and asked what the Supreme Court ruling implications were for incentivized commission decisions, and it says final takeaways. The FCA's earlier ban and disclosure reforms remain valid and critical, confirming that commission models that incentivize higher borrowing must be deliberately explained to customers. Today, UK Supreme Court ruling affirms the principles of those FCA interventions, although in a narrower way. Not all DCAs are unlawful, but undisclosed or deceptive schemes are. This is Paul's point. Consumers may still seek compensation for motor finance deals before January 2021, where disclosure and informed consent were missing. And firms across financial services must revisit their remuneration and commission structures to ensure transparency and alignment with consumer duty. So I don't know if that's any help, but that's...
It's helpful. Howard, thank you very much for doing that so quickly. What else is helpful is the note that Tim Layton just put in the chat. Tim's indicated that Martin Lewis has just been on BBC saying it's 10 to 15 billion. Paul, any comments in relation to what Martin Lewis has said? He's saying it's going to be 10 to 15 billion. Paul.
Deep breath. Don't say what you really think about Martin Lewis on car finance. No.
Just answer the question, Paul.
Yeah, no, I mean, well, you've just heard me say there's 15 billion entrenched, right? That's now done. You know, that's in the bag, in the bank, happy days. But I do think there's going to be a little bit more. So I'm not surprised Martin's saying that. I've corrected him so many times in the last 15 to 18 months that I'm sure he's got it now. But yeah, I think, but I don't know. I just don't really understand why. You know, why they're all. Let's think about that. These firms are now going to pay 15 billion quid, right? That's a lot of money, right? And it does have the door is open there on the insurance and everything else. But for me, the great thing is that there's so much evidence that has never been opined on by any of these courts. The doors are open for us to go in properly, big time, with the law firms I'm working with, and we'll nail them on the rest of it.
Thanks, Paul. Thank you so much. I'll tell you what, your comment just now and what Tony said has got me thinking, is this about controlling the narrative? I mean, you know how, and by the way, folks, genuinely, what I'm about to say is not in any way party political, but some people believe that Donald Trump has been effective in talking about 35–40% tariffs, and when countries only get 15% tariffs, everyone kind of sighs relief. Had it been the other way around, you're now having to deal with 15% tariffs, it would have been a nightmare. I wonder if there's a controlling of the narrative exercise going here, whereby the law has had to be implemented as the law is written, which means there's going to be, let's say, 10 to 15 billion pounds in compensation, but it's been done in such a way that it's actually been dressed up as a win for the banks. I wonder. Ian, very, very quickly, then we'll wrap up. Thank you very much. Thank you.
Yeah, very quickly. The one thing that I found interesting was the fact that the Treasury applied to the court to get involved, and the court rightly said, bugger off. This is about the law. It's not about economics. Because the Treasury was wanting to plead, obviously, and we know where this is coming from. This is coming from bloody Starmer and Reeves, right? That, oh, there's going to be a problem here if you find for everybody in this case. So I'm not convinced the court have deliberately awarded what they think is a go away sum of money. I think from what I heard them saying, I think they have made the decision rightly on the facts of the matter as the law sees it. The case, yes, the cases would have been more successfully pled differently, but I am so pleased that they told the Treasury to bugger off. But to me, the question is, why was the Treasury even trying to get involved? Because to me, that's a no-no. But I'm saying why. We know why, but I just think it's disgraceful that the attempt was even made.
No worries. Thank you very much indeed, Ian. Thank you. Alrighty. Well, what an interesting situation. I had expected to come away from the verdict with a binary understanding of what the decision was. I'm now, to pick up on what Lisa was saying earlier, a little bit confused about what it really means. It's going to take a few days to suss whether what's actually just happened is a remarkably successful controlling of narrative exercise, or in fact, whether the banks have just scored a great victory. We'll find out. Thank you very much indeed. Have a lovely weekend, folks. Thank you. Cheers, Paul. Much appreciated. Thanks, Ian. Thanks, Tony. Thanks, Howard. Thanks, Nigel. Thanks, everybody who's chipped in. Thank you. Thanks, Trevor, too. Thanks, Lisa. Bye-bye. Good night. Good night.